Yes,
So the majority of the questions which follow are questions which I've been invited to ask you by core participants, and they're going to therefore dart around somewhat from topic to topic. But the first set are on the subject of research, which we were discussing prior to lunch. What kind of information about a patient, gleaned either from research or from clinical treatment, can be used by a clinician and put into the public domain by a clinician ethically without the patient's consent?
Well, having just finishing editing the Journal of Medical Ethics, I can say none at the moment. So the British Medical Journal group, require patients to consent even if all identifying details have been removed from the description of their case. So at least within that publishing group, it's not possible to even put de-identified case histories, anonymised photographs, any details in the public domain without the consent of the patient.
Thank you. Any other observations on Professor Phosphides?
I would agree with that. I can only speak from the perspective of conducting qualitative research. So that is research that's actually trying to get a patient's views and life experience. So of course it's very easy to see that as potentially identifying somebody. And not only do we pay attention to the possibility of that happening and it being an issue, but of course the important other people in that person's life might be identified by the stories they tell or the associations that are alluded to. So I think certainly when we're talking about information that's gained through what we see as increasingly important research that touches upon the experience of people who have had particular diseases or undergone particular treatments, we want to be absolutely sure that they understand the implications of how we will use that data, to what extent there is an intention, for example, to directly quote people, how they might be described, even if we give people pseudonyms and slightly change the description, we would want everybody to feel absolutely comfortable with how data was presented. And certainly in my own case, if I was relying heavily on reported data, I would share drafts of publishable material with my participants.
But it's important to qualify both what we've both said. In the past, that was not the norm. In the past, photographs with eyes blacked out or de-identified case histories could be published or were published without consent.
And sadly, not in the distant past either. I mean, there have been relatively recent cases of people challenging journal editors or becoming very upset when monographs are published that alleged to have presented anonymised patient accounts that are nonetheless very recognisable to the people involved.
Should patients be informed of the outcome of research that they have been part of, and also informed when it's been published?
Ethically, I think they should, and I think that they should be provided with an intelligible report of the research that they've participated in. Again, that has not been the standard. That people have been notified that the research they participated in has been completed and what the results were. But I believe that ethically they ought to be.
I agree, and you can take different approaches to doing that. For example, you could provide people with a web link from when they start participating in the research and undertake to update that regularly so that they know about the progress of the research. Unfortunately, some people never get to learn that research wasn't concluded that they had been a part of. And interestingly, when we spoke to children and young people about this matter, it was one of the ones on which they had the strongest view. They were absolutely outraged at the thought that they could participate in research and never learn what happened and what benefits followed from it.
And what Julian and Bobby has said is something that's also seen within the Declaration of Helsinki. So paragraph 26 requires that participants are given the option of being informed about the general results of the study.
What about audit? Or something that might be in that grey area between audit and research? Do the same considerations apply?
Historically, patients have not been informed of the results of audit. They've been used internally for improving quality of service delivery. But as I think Emma has said before, the boundary between research and audit has been blurred. And there is an argument now that where the results of an audit would be relevant to patients, they ought to be informed of that result.
Yeah, I think that's right. It depends on what that audit reveals. But it's important to recognise that even though with audit there isn't a requirement for review from an ethics committee, there is still a requirement of ethical oversight. It doesn't mean that audit doesn't contain any or doesn't have any ethical issues or require any oversight.
Is the reason or a reason for there being different ethical requirements relating to clinical and non-clinical research, that in the former case it's assumed that proper informed consent to the treatment being administered has already been undertaken?
I don't think you would make anything rest on that assumption, because consent to treatment doesn't necessarily entail consent to what will be undertaken during the course of the research. If you felt that if you felt as a patient that consent had always been very well managed in your clinical experience, that might give you some confidence to expect the same in a research setting. But I don't think you can assume that just because things have gone well around consent to treatment that relieves you of a very explicit obligation to get consent to anything that falls under the heading of research.
It's also important to recognise that research is extremely broad, and non-therapeutic research can refer to many different kinds of research, which might include observational research. And I think people in the past have thought that because you weren't doing anything to somebody in some kinds of non-therapeutic research that you didn't need to get consent. That, however, has changed in recent decades.
Given the difficulties that you've referred to that there can be in distinguishing between research and audit, to what extent is there an obligation ethically to seek advice on whether a proposed course of action is one which requires ethical approval before embarking upon it?
I think when the boundary becomes blurred between audit and research, and sometimes in big projects there are aspects and elements of both. In that situation, that particular situation, then this would probably require formal ethical approval, because otherwise there might be ethical issues that need to be resolved.
I think there are some default positions that we should adopt in these debates, and so when in doubt, talk to the patient. When in doubt, seek the feedback of an ethics committee about whether it needs to be consulted. So in general, there should be a default position of protecting the interests of the patient or the participant, or of getting consent, or involving others, in the oversight of that project. So, I think we need to start with ethical defaults, not unethical defaults.
You talked before lunch about something. Oh, sorry, Professor Kay.
It was just a minor point that It's relatively easy now to work this sort of thing out. There are tools that can be used that you can follow on the HRA website to help you work out whether it's something that requires ethical approval. But there was more of a blurry line in the past. And to apply to the ethics committee just to get a response saying, no, actually, this isn't research, might have taken a long time. And so that's one of the factors that might have been relevant when people were trying to make that decision.
You talked before lunch about something, a project might look like research. And can I ask you about whether the two examples, hypothetical examples, and how they should be treated? A course of action, a study where the publication of the results has always been likely, is that something which should be treated as research rather than audit?
Yes. In general, if you're thinking of publishing the results, it's usually considered to be research.
As Julian suggested, journal editors have actually been quite influential on this matter of not allowing too easy a distinction between research and audit, and therefore requiring that when submitting publications to a journal, it's clear that, as Emma put it, there's been sufficient and appropriate ethical oversight, whether it's research or audit.
And the reason for that is if it's being published in a journal, it's original knowledge. It's not really just internal improvement of service. So that's why it got into a journal, because it's creating new knowledge that needs to be shared within the academic community.
And I think this may follow from the answers you've already given this afternoon, but would that also be the case where the subject of the study is an identifiable group of patients for whom anonymisation may be much harder to achieve, haemophiliacs within a certain geographical location within a certain period of time, for example?
I think one of the strongest moral obligations upon researchers who work with small and identifiable populations is ensuring that, as far as possible, their confidentiality and privacy is protected. And therefore, if you feel you need advice on that, it's possibly too late to wait until you've got something to publish. It might be right back at the beginning of what you intend to do that you need advice on how to code your participants, how to describe without being misleading in a scientific or social scientific way who and where they are, in order to preserve their anonymity as far as possible.
It's also worth pointing out that anonymisation isn't always a panacea. One of the things that a research ethics committee would want to look at is how effective anonymisation might be in a particular case, because taking away somebody's name doesn't necessarily mean that you can't piece together who something is about. So that's something that the great care needs to be taken over.
And then how does an ethics committee ensure, or how, what other mechanisms exist to ensure that undertakings that have been given about proposed research or conditions attached to research have been adhered to? How, for example, does the ethics committee satisfy itself that informed patient consent was actually taken?
It's interesting that some of the historical documents that we've looked at over the past few days that you've shared with us say, oh, it can't possibly be done. You know, once the research is approved, then, you know, it's quite difficult to see what happens next. And I think it did take quite a long time for ethics committees to think very constructively about how you might monitor the actual progress of a piece of research that you have given approval to. And certainly on a very specialised research ethics committee that I chair, for as long as the research is ongoing, there is quite a detailed form that is sent out to researchers that would hopefully capture anything that was not going as it should have been given the terms upon which the original approval was given. So I think ethics committees are more alert to this, but the work involved in that is quite substantial. And if you were working in an NHS committee with a much larger flow through of research than the one I'm referring to, it might only be that you could sample a small number of projects a year and follow them through. But there is a recognition that your responsibility formally ends when you give approval, but your ethical interest in what happens next should remain live. And if you have a way of practically monitoring that, then it's certainly something that one would want to happen.
But this is a fairly recent thing. So the idea of monitoring decisions to make sure that researchers are doing as they promised to do is fairly recent. For many years, it wasn't done. There was no capacity to do it. And I think still in some institutions, it's not done as effectively as it might, or perhaps there's a lot of variation in how it's done, perhaps across universities, for example.
When you say fairly recently, are you able to give us an idea of how recently?
I can't be exact, but in the 90s, I was involved in a paper writing about the idea that there ought to be monitoring, and there wasn't at that point. So I would imagine sort of late 90s, but I can't be exact on that. My apologies.
So I haven't followed the developments in the UK, but I know in 1999, the Australian Health Ethics Committee constructed what's called the National Statement on Conduct in Research, and that placed monitoring responsibilities on ethics committees to continue to monitor the conduct along the lines Bobby suggested, but also including site visits. So it was I think it was 1999 exactly when that became a responsibility of ethics committees in Australia. Now again, I don't know if that's been made the case in the UK, but it certainly illustrates that around that time there was an expectation that it wouldn't be just you approve the project, but that you ensure that that deviations are reported, adverse events are reported, and that you monitor the conduct of the research.
And I think other parties have become interested in monitoring the ethical conduct of research. For example, funding bodies. I mean, my first meeting tomorrow morning is in a role as a member of an independent ethical advisory group for a very large and complex clinical trial. And it was the requirement of the funders that such a body be established and keep a quite close eye over the conduct of the trial, not looking at the science, but specifically looking at the ethical issues that might arise and giving support, advice, but also finally maybe giving comment on whether or not it was thought that the study was sticking to the terms of the permissions given by the ethics committees.
Dr.
The
Kazarian?
paper I wrote on it was in the year 2000, so it seems we were behind Australia again, sadly.
Dr. Kazarian?
Agree. I think the work of research ethics committees is an ongoing process, and it's important that they are important to preserve ethics and the ethics of a research project, not just at the stage of the ethics approval, but if there are changes during the study and there are amendments made, then they have a role as well. And that's why more recently, as has been said, this monitoring role has become more and more important.
You have said in your report that there may be large cohort studies that could be approved whereby anonymised data is provided over a period of time to inform scientific knowledge, etc., and particular patients might be unaware of their involvement in that, but that there should be a general public awareness of the existence of the study. And The question I wanted to ask arising out of that is, what kind of steps should either clinicians providing data or those controlling the data take to ensure public awareness of such studies, particularly amongst relevant patient cohorts?
It's interesting that in this regard, there's a thing called the Caldecott Guardian, which is after a review of patient identifiable information in 1997, this review chaired by Dame Fiona Caldecott set up a governance system whereby there would be Caldecott Guardians in each institution in the NHS. And they very recently set out a new principle. So they started off with 6 principles and they've added 2 since then. And one of those is the duty to tell patients how confidential information is shared, where it's going to be shared. So I think this is a recognition of the fact that things have changed over time, and the methods too will have changed over time. So now it may well be that websites are used. Previously, it might have been that there was more focus on leaflets in the right places, in places where people were more likely to come across them.
If, for example, there's a national register for a particular condition on which a patient's details are entered, would you expect ethically that patient to be notified that their details are going to be entered into the registry?
It's not quite so straightforward, I suppose, because it depends what they're going to do with that registry. If it's for research purposes, for example, then the ethical requirements might be different. The optimal situation will be that there is explicit consent to that. But there are exceptions to that, which we discussed before the break. So there are situations where the law allows, subject to application, registries to collate data without getting informed consent in each instance.
So for example, there are cancer registries where cancer information is submitted. I think ideally, as Emma says, the idea would be people give explicit consent. Next best would be that they're informed that this information is available, and the next best option would be that there's public disclosure and information about such registries in a way that if people are interested, they can find out whether their information is going into those registries. So, for example, there was a large scandal recently when the NHS provided data to Google DeepMind, and that's an example where I think people should have been made aware of the nature of that project, its value, the protections in place, the financial arrangements, and better public information disclosed in an accessible way. There's been a greater movement towards disclosure. For example, registries of clinical trials. In the past, there wasn't a requirement to make public that you were performing a clinical trial. And now it's been acknowledged that that's important to find out what is going on and how many trials are not publishing their results, or if their results aren't being published. Because that's another big problem in research, where negative results are not published. Trials are repeated when it's already been shown that some intervention is ineffective or harmful, and generally knowledge is not advanced. So things have moved on a lot, but I wouldn't know whether, I would have to know more about the precise nature of the situation to say whether it's ethically important to, or ethically mandatory to directly inform patients of a particular registry.
One reason that things, sorry, I beg your pardon. Go ahead, Mel, because I've spoken already.
No, just following up on that particular point, the Caldecott report recognized that actually the duty to share information is as important as the duty to protect confidentiality. and it might be sometimes in the patient's best interest to share that particular information, but the purposes of the sharing of information must be justified. So that's another important requirement from the report.
The law on data protection has become clearer over time. Until the Data Protection Act 1998, it really was very unclear. And even after 1998, there was a lack of clarity as to the sort of consent, whether it should be express or whether it could sometimes be implied, as to what would suffice. And the same really can be said about the law of confidentiality. So we had a law saying that we must keep information secret under certain circumstances, but there are a great number of exceptions to that. And the clarity with regards to those exceptions wasn't great.
I think another thing to think about is that alongside the growth of our recognition of the value of medical data and the sharing of, and I think it's really helpful that Mel's reminded us of that element of the Caldecott recommendations. Alongside that, we've got a growing amount of evidence of what the general public think on these matters. There's been quite substantial research conducted. There's been across the nation citizens' juries. If you look at establishments of projects such as the 100,000 Genome Project, which was going to be responsible for storing a huge amount of sensitive data, one of the first committees established as part of that process was the participant panel, so that people who themselves were going to be part of the project could have a say and advise and comment on the arrangements around the sharing and storage and use of data. So if we were wanting to feel a bit more positive about the direction things are going, I think that's where to look. The idea that this is no longer an area where decisions are made by doctors or even, information technologists and specialists. It's an area for public debate, public engagement and involvement, and very specifically in areas where, patient communities feel that they have particular concerns or interests, the involvement of those with lived experience.
Is there an expectation ethically that a clinician who is involved in medical research in relation to developing products or has an involvement with a particular pharmaceutical company will tell their patient that if they're proposing to treat their patient with that product or with a product manufactured and supplied by that pharmaceutical company?
I would say yes, that now, I think it wasn't clear before in the past, but now if there is a particular or possible conflict of interest, for instance, then that needs to be disclosed to the patient or the research participants. Sources of funding as well is something that needs to be disclosed to the patient, and I think that's made clear in the Declaration of Helsinki as well.
Professor Kay.
There was also some guidance around the 1980s on this. So the Royal College of Physicians in 1984 said that in research it was important to report any payments to research ethics committees so that they were aware of them. That's not the same as reporting them to the patients, of course, but at least it's requiring that there's an openness. The GMC around the same time said that it was improper to accept payments unless they're approved by a research ethics committee, same as the RCP, but also said that the same applied to treatments where clinicians were asked to report adverse events or incidents per capita, which they saw as a sort of quasi form of research. More recently, we have the Cumberland Reports, which I know I've alluded to a number of times, but it made very important recommendations with regards to mandatory reporting for pharmaceutical payments to hospitals and research institutions, and also to individuals. And the GMC has agreed that it would be a useful thing to set up a list of financial and non-pecuniary interests for all doctors. So that's, I suppose it shows that this is something that has been an ongoing problem that we haven't quite worked out the solution to. but hopefully one is just around the corner.
Wanted next to ask you about training in medical ethics for doctors. To what extent, since 1970 or thereabouts, has there been training in medical ethics for doctors as part of their as part of their professional training and qualifications? Professor Farsidis.
I don't think you would go as far back as the 1970s. There may have been, a lecture, but I think it might have been very much in the terms of the etiquette model that we keep coming across in the documents of that time. I myself have been involved in medical ethics since the mid-1980s. That was relatively early, and the education initially was more likely to be postgraduate education, I think, for interested professionals who wish to develop skills in that area. From the mid-1980s, Professor Ronan Gillen, whose name came up yesterday, established a very thorough, respectable, intensive course at Imperial College that still runs to this day and attracts people from around the world. But in terms of medical schools, it took longer, but once it happened, it happened. The GMC decided, as I think I said yesterday, that ethics should be a continual strand through medical education, because there's a sense in which you can't unpick where it is and isn't relevant. There's the potential for relevance throughout. There's very few topics that the students learn that are completely devoid of the possibility of an ethical complexion. Different medical schools have developed different curricula. They choose to deliver the teaching in different ways. It sometimes depends upon the specific interests and specialisms of the ethicists involved in the teaching. It may be that as in our medical school, we have a lot of team teaching alongside clinicians, so that you make sure that what you're saying is very much related to the clinical experience of the students. And alongside this, a community has grown up around the discipline, with some very active bodies such as the Institute of Medical Education, which supports and promotes ethics in medical schools and encourages medical students to think of it as also a sort of extracurricular activity, with debating contests and competitions for writing journal articles, etc. So it's something that's changed over time. You now find I can't think of a medical school that doesn't have substantive members of staff working in this area. It will vary how many, but now I don't think you could graduate from a medical degree in a British university without being aware that you had been taught a substantial amount of medical law, ethics and law.
So just to, Bobby is the expert, but I think 1998 is a sort of key year. A group published a core curriculum in the Journal of Medical Ethics. Bobby was a part of that group. And around that time, the GMC mandated medical ethics and law teaching in medical schools. So it went from this very disparate, informal form of teaching to something that was really a part of core medical education. And around that time, Tony Hope and I wrote our book on medical ethics and law textbook for medical schools around that core curriculum. So I think it's really the late 90s where it became, a core part of medical schools. But as Bobby says, that there is still considerable freedom and choice around how that's delivered and what is actually delivered. So I wouldn't by any means want to think that the job is done and that doctors are completing their education with a good knowledge of medical ethics and law.
And the 1998 publication to which you refer, that's the consensus statement by teachers of medical ethics and law in UK medical schools, which is, I think, referenced in your report, and to which you were a signatory, I think, Professor Farsidis.
Yes, that's right.
we touched yesterday, and you touched on it in your report, on the limited nature of legal remedies. For example, there is no freestanding claim for damages for the absence of informed consent. Is there any evidence that you're aware of that the existence of legal remedies drives up standards of care and helps embed ethical standards?
I think we've seen some evidence of that in the various documents that you've put up. So where there was talk from the Medical Defence Union, for example, about consent, it referenced assault. And that was, so the thinking then was to how can we advise people on how to avoid a claim an assault? But then that was from the Medical Defence Union, so fairly clear that was going to be their emphasis. It's more of a symbiotic relationship, I think. It's not that one drives the other. It's that both are relevant to both. The law can be a lot slower to move than ethical guidance. But as we heard over the course of yesterday, sometimes codes too can take a while to be changed, to get consensus, to get agreement. They can be fairly slow moving too. So things move at different strands at different levels. But there certainly are cases where changes in the law have driven changes to guidance. Montgomery is an example of that. I mean, it's strange in a way, because Montgomery came about, in part, it recognised that the GMC had recognised for many years a standard of informed consent that hadn't been fully adopted by the courts. Yet the GMC then went on to revise their guidance in order to take account of some of the nuanced aspects of the judgment, such as the reference to the therapeutic exception, which we've talked about, and reference to dialogue and the importance of dialogue, and to really draw that out, to operationalise some of the legal aspects that Montgomery had set into law.
Moving to a different issue now, what ethical principles guide how clinicians should guard against stigma or conscious or unconscious bias in their practice? Professor Farsidis.
Again, I think you would not have heard this term unconscious bias mentioned within a medical curriculum until very recently, probably. But certainly the GMC has been very aware of the impact of unconscious bias when considering how the fitness to practice processes operate, and the ways in which people's judgments of what happened might be skewed somewhat by biases they simply do not know that they hold or operate. Stigma is, again, I think something that for many years was not well understood and could too easily be overlooked, even by the most dedicated clinician. And it's since medicine has become more open to working in partnership with disciplines such as anthropology, sociology, ethics, that we've worked together to define, understand, and then move on to try and find ways of minimising experiences of stigma. But it's a huge challenge, and it requires a lot of careful work, and the work doesn't stop in terms of what you manage to achieve as an individual doctor and patient. Stigma is a societal problem, and what we sometimes need is the expertise of all those who've come to recognise the existence of stigma, to be applied to sharing their knowledge and understanding more widely, so that we try to tackle it as a societal problem.
The next question is again on a different topic. The process of death certification. I know the panel doesn't claim any particular experience of or expertise in relation to that process. But ethically, what are the implications of omitting or obscuring a cause of death on a death certificate for what may be well-motivated reasons of avoiding distress or preserving confidentiality?
Well, I mean, first of all, it has implications for a health system and for other patients. If death is not accurately recorded, and we can't understand what's happening with patterns of death or with perhaps adverse events in hospitals or around clinical care. So first of all, it's essential that death certificates are accurate for medicine to advance. Secondly, it can deny the family appropriate understanding of the circumstances of death and perhaps even their risks or matters to do with their own future well-being, and also to do with any future redress. So, for example, to take one personal example, my father had died when he was in hospital for the investigation of jaundice, and during a radiological examination, a needle pierced an artery in his liver, and because he was 87, he was essentially allowed to bleed to death. And the death certificate recorded a heart attack, which I didn't challenge, but which was inaccurate. And if I had wanted to pursue a legal case, would have made pursuing that legal case more difficult. So it denies people the opportunity for legal redress if the death certificate is misleading or inaccurate.
Professor Kay.
The GMC says that death certificates must be completed honestly and fully and to the best of the clinician's knowledge and belief. But I think it's also true to say that it isn't an exact science, that it isn't always clear what a main cause is and what an underlying or a cumulative cause is. And so there is an element of subjectivity, but that comes within the broad ethical requirement that the completion of the certificate should be honest and full and to the best of the person's belief.
I agree with all of that, but it's interesting, isn't it, that it goes against Mel's point earlier about retaining privacy in death, because there may be information then provided in a very public way about the manner and cause of somebody's death, which I absolutely agree needs to be publicly known, but may nonetheless be problematic in confidentiality terms. And I also remember in the very early days of HIV and AIDS discussions about the possibility of almost having two versions of a death certificate. Such was the fear of stigma and the wish of families not to be exposed as they felt they would be by local knowledge of the cause of death. So you would record the death and how, it was incredibly important in order to understand the epidemiology and the prevalence, etc. But that you could have a document that would be somewhat more euphemistic. And we all know that very common euphemisms arose in that context to be used by the family in public spaces. So I think whilst it is crucially important and sometimes important to the family that they have an openness and transparency to relate to, it's not unproblematic because of the impact of certain diagnoses and causes of death.
We spoke yesterday about team decisions, team working. You may to some extent have answered this question already, but the question is this: does an individual clinician bear ethical responsibility for a multidisciplinary team decision that is ethically wrong?
Well, typically, as we were saying yesterday, there is a senior treating doctor who is responsible for the overall oversight or management of the patient. And and that doctor, unfortunately, like the Prime Minister, has to take responsibility for the decisions that that they ultimately make, even if it's the result of a team decision. So normally there is a doctor who will be the primary person who is responsible for that care. The patient will be under that bed card, under that consultant, and that person is responsible for getting whatever input, including team consultation, that they require. But it is ultimately an individual decision, not a not a parliamentary vote.
And I agree that there has to be somebody ultimately who holds responsibility for a team's decision, because that person has also to some extent got responsibility for the proper functioning of that team. So if you are the chief consultant and your team is not working in a way that upholds the best interests of patients, or doesn't show due regard to keeping up to date with research or any of the things that we've discussed so far, you've got a systemic problem before that translates into an individual problem. And it might be that we go back to look at the actual functioning of the team as well as the particular decision that was made, because sometimes, for example, if junior doctors are not well supported, and senior colleagues do not make themselves adequately available to advise or support, that might be at the root of the problem. And it is, as I say, a problem, a systemic problem that would then need to be addressed to ensure that future incidents of the same type did not occur.
So where there's a controversial case or disagreement between, say, the team and the lead consultant, or amongst the team, there are various ways of escalating the responsibility. So, for example, I was peripherally involved in a controversial case in Australia of a late termination of a 32-week pregnancy for dwarfism. And that involved at least 5 different specialists who all were in agreement, but because of unclarity in the law, contacted the hospital medical administrator to involve medical administration in the decision. You can also involve the hospital lawyers in terms of seeking an opinion from them about the legality of any proposed course of action, or seek the view of an ethics committee in terms of advice on the case. So when there are different views, it can go in an escalating way, and ultimately it can go to court for a court decision about which course of action is in the best interest of the patient. So it will depend on how controversial it is and what the nature of the disagreement is, and the extent of whether you want to escalate the case.
To follow on from Julian's point, it can be escalated, of course, outside of the institution. Julian mentioned court. The GMC also has a role which means that clinicians can report issues to the GMC, which will then act upon that. It's also interesting that the recent report into the actions of breast surgeon Ian Paterson, the James report, that reported not just the wrongful actions of one individual, but the willful blindness to those actions by those around him. And I think there has been for some time a problem with regards to whistleblowing, with regards to the protection of whistleblowers in the NHS. And there have been various statutes and guidelines that have tried to resolve that. But in the past, that was even more of a problem than it is today.
May I just ask a question? We've been talking here on and off in this last question and answer about responsibility and team working, and a clinician, the lead clinician, having responsibility for the team. What if we take this example? Suppose that part of what is identified in somebody who is being treated by the lead clinician who is a haemophilia doctor, is that the individual suffers from a liver condition for which he is referred to a hepatologist. Both are, in one sense, part of the same team because they're both administering care to the same patient. Who takes responsibility? Someone overall, or just each for what? Because in some cases that we've heard about in the inquiry, it may have been the case that the haematology doctor would keep, as it were, the patient as his patient, and the hepatologist would visit. In others, it would be that the hepatologist would have a separate clinic. Who has responsibility and for what? How do we decide?
Well, I think it's a shame we don't have Ian here to answer that question, and maybe we want to pose that to him in writing. My understanding is that it depends on which is the dominant problem. So, for example, to give you an analogy, often patients will end up in intensive care with an intensive care specialist as their main doctor, but they'll have a neurosurgeon involved, maybe a cardiac surgeon, a neurologist, and in that case, the neurosurgeon will be responsible for the neurosurgical aspects of the care, but the intensive care consultant will be in charge of the overall management and coordination of these different specialties. Then the patient may in the end be discharged out of intensive care to neurology, and that consultant then becomes the primary consultant. So it would depend on whether the main problem was hematological or whether it was hepatological. And that person would be, if you like, the main coordinating clinician, and the other one would be secondary, and that may shift according to the way in which the problem evolves. That's my understanding of the distribution of responsibility in medicine, but it's been a long time since I've been actively involved in it.
I think I would agree with that, and I think there is a difference between moral responsibility and ethical responsibility and legal responsibility. And often in healthcare failing cases, as Bobby has mentioned and Emma's mentioned, there are a lot of systemic issues which come to play, and that has an impact on how care is delivered to the patient. And in these cases, it is often very complex to attribute responsibility to one particular person. Ethically, I think that if a doctor, a clinician has a patient to whom they are delivering care, then ethically they are responsible towards that patient for their well-being. Legally, it's more complicated. And it could be argued that sometimes responsibility must be shared and distributed, but sometimes it might be a case of actually that's a systemic issue, and therefore it is very difficult to attribute responsibility to one particular person.
And there is a problem, Sir Brian, with patients falling between the cracks there where nobody knows who's taking responsibility. I mean, my memory, and again, Ian, I think we should ask, but my memory in haemophilia was that clinics were, at least in Australia, very protective of the patients and tended to maintain primary responsibility regardless of the other problems, and retain that responsibility for coordination of care because there was, if you like, a community around that group of patients. But it is a complicated area where people can easily fall through the cracks.
Because presumably the patient needs to know who is really going to take responsibility for their care. Yes.
And I think the most important thing is that that's decided and it's clear to the patient. In some ways, it really will depend on the circumstance, but it needs to be clear who's going to take over the overall responsibility for ongoing management and coordination.
Returning to the issue of informed consent, and this question would relate both to consent to treatment and consent to participation in research. How does one guard against the dangers of a clinician effectively sugarcoating the message by emphasising the positives and benefits of the treatment or the proposed participation and downplaying the potential adverse consequences and risks?
Well, that's not informed consent. I mean, it's not. The person needs to understand accurately what the risks and benefits are, not have a misperception. And of course, I mean, it can be. We talked about subconscious bias as another thing in the last 30 years. Is an acknowledgement of the heuristics that we operate under, psychological framings. So whether you simply frame something in one way in terms of gains instead of losses will tend to push people into choosing the option. So you can present exactly the same information but framed in a different way and will influence patient choice. And that is a big obstacle to enabling fully informed and autonomous choice. So, ideally the information should be presented in a number of different ways to not hijack these biases or heuristics that we all operate under.
And I know I'm beginning to sound like a broken record, but I think, again, this topic tells us of the experience of learning from people who maybe have gone through these treatments before, because it's not only the case sometimes that a clinician unconsciously or otherwise could sugarcoat the risks, but there was some interesting research conducted by Maurice Slevin many years ago around the risks associated with chemotherapy. And he conducted some scenario-based research with patients, nurses and doctors, asking what sort of risk would you be prepared to accept in order to acquire this type of benefit. And what his research revealed was that the doctors and nurses were far more conservative around risk than the patients. So there is also the possibility on occasion that without understanding patient experience, your presentation of risk could err too much on the side of caution. We worry much more about those who sugarcoat or misrepresent risks in a way that makes them unexpected or completely obscures them for the patient. But I think we should also think that if we continue to make decisions without any reference to those who have direct experience, we have a risk of going in the other direction as well.
Yeah, I mean, just to illustrate, sorry, Emma, did you want to come in? But just to illustrate that point with this issue of framing, I mean, say you have a patient with a life-threatening condition, and you say to the patient, we can do an operation, but there's a 20% chance that you'll die. People will tend not to take the operation. If you say, there's an 80% chance you'll survive the operation and be cured of the condition, they will tend to take the operation. And so that's what framing effect is. So what's important is you present them with both information, both framings, and enable them to make their own decision about whether to take on the risk or not. And that's really something that hasn't permeated entirely medical practice now. And I think that's going to be a challenge for the future. Sorry, Emma.
No, not at all. I quite agree with what you said and what Bobby said as well. I just wanted to add the proviso that in some cases, patients will ask the doctor, what would you do? And in those cases, it's acceptable for the doctor to say, this is what I prefer to do. That's an entirely different thing to sugarcoating and not giving the information properly. But I think it's important to recognise that does sometimes happen.
Although in some areas of medicine, and particularly in nursing, and often I think we mustn't forget that the nurse is the person someone turns to and asks that question because they're sometimes more accessible. The person might have got to know them better and feel more relaxed with them. there's a long-standing tradition of what we call non-directive counselling, and the idea that actually, particularly where the decisions that somebody makes have an ethical complexion to them, such as whether or not to terminate a pregnancy due to a fetal anomaly or such like, that question is often batted back to the patient as something that can't be answered because that would be directive. And then you need to support the clinicians in having sort of communication skills level 1B, such that actually you can still enter a meaningful dialogue with the patient around the concern that they're raising, and not just say, I can't answer that question.
The next question is for Dr. Kazarian and Professor Cave, and it may be one that you can't answer but would be able to in writing. It's this: are you aware of any cases, civil or criminal, where testing without informed consent has led to litigation and resulted in a concluded or reported case?
There was a case called REC involving consent of a child, consent of parents in relation to HIV testing of a child, which is interesting because in 1988 the GMC recommended that it wouldn't necessarily be the case that you'd need to get consent of parents in order to test a child, and I think that was highly controversial, given that we've discussed over the last couple of days the importance of having a valid consent to avoid the possibility of an assault. So in this particular case, what happened was that there was a question about whether the child should be tested for HIV. The parents objected, said they didn't want that to happen, and the court decided that in this particular case it would be in the best interest of the child to be tested so that any treatment that the child might need could be delivered. So that's one particular case. There's also the case of S&S, which is a 1972 case, where the House of Lords said that taking blood from an adult against his will is contrary to the law because it interferes with his personal liberty. That's a slightly different situation because that was the actual physical act was against the person's will, rather than the issue of whether the individual was aware as to what was being consented to. So there are two cases. I'm not sure that that's comprehensive. There may be others, but they're the two that I'm aware of. Do you know of any others, Mel, that might be?
Those are the two I'm aware of as well. I can have a further look and maybe respond in writing if that would be helpful.
The next question picks up upon a discussion, I think, led by Professor Savulescu yesterday about hard and soft paternalism. I think it may be that this question has effectively already been answered by your evidence yesterday, but I'm asked to ask it. Does a failure to provide a capacitous patient with information known to the clinician in order for them to make an informed decision amount to hard paternalism?
Yes, unless there is some deficiency with the decision-making capacity, but if, as you stipulate, the person is fully competent, rational, thinking clearly, yes, that's a case of hard paternalism, and that's generally taken to be unjustifiable.
And then, again, in terms of clinicians failing to obtain or provide an opportunity for patients to give informed consent, we've explored the role of paternalism. Is there any research or understanding as to the extent to which that type of behaviour by clinicians may have occurred, not because it's paternalistic, but because it's easier, it's lazy doctoring? Is there any research or work along those lines? Professor Varsides?
I wonder if the question has emerged because of the emphasis we placed on the beneficent motivations of some paternalists, and it's trying to make a distinction between those who chose to take that route genuinely because they felt they had reasons to protect and go against what we might think was the best interest of the patient, and those who simply either had a habit of behaviour or felt that this was the way that things was done, or more, as the question poses, realised it would be much more difficult to follow the other path, and maybe time should be spent on more important matters. I don't know. But I don't know about specific research that reveals the extent to which either of those patterns of behaviour existed. But what I would say is I think it's a useful distinction, because however much we would prefer that things had moved away from a paternalistic model, we can at least allow some sense of it being attached to beneficent intentions. Whereas if we go for the sort of example that I think is behind the question, then we can't be so generous initially.
Can I add just something to what Bobby said? I think it is a useful distinction, but I think you need a tripartite distinction. You need to distinguish between beneficent paternalism, even if it's misplaced. You need to identify lazy or other, what is sometimes called vicious practices, practices which just represent a flaw in the physician. And the third category, which I've alluded to, is people operating as best they can within a system which just doesn't allow them to do the right thing. And I think that some of the problems may be the result of systemic problems. So there's a difference between not having enough time to engage in a difficult discussion and not wanting to because it's difficult and you'd rather do something else. And I don't know of any systematic research on this, but my strong suspicion is there's a mixture of all three in practice, and just how much of it is vicious and how much of it is the result of a very flawed system is difficult to say.
I think that's hugely helpful, Julian, and I think it also helps us to understand how people might look back and reflect upon what happened in some cases with personal regret, with some acknowledging belatedly that the system had not allowed them to do what they would wish to do. So I think that's that trio of examples is really helpful.
Professor King?
It's not research as such, but in relation to lazy practices and also practices where doctors may have been operating as best as they can, we've seen a number of examples in recent public inquiries. I've mentioned already the Patterson review, where there was a complete failure to get consent in some cases, and professionals sort of protecting their own. I've also mentioned a couple of times the Cumberland review, where there was avoidable harm to patients because they weren't listened to, and consent is a theme that runs through that report as well. And then we very recently have the interim report from the Omitting review, and that's a review about caesarean section rates and trying to keep those as low as possible, and failing to listen to women who actually wanted another course of treatment, and the result has been deaths and injury to babies and to women. So we do see examples of the three categories that Julian was referring to in some of these public inquiries.
Following up on that point as well, and I think Julian is completely right about these three categories of practices. I think there are common themes to different healthcare failing episodes that we've seen in different inquiries. Like Emma said, the lack of information given to patients, the lack of transparency, the lack of openness, the failure to actually listen to patients and listen to their concerns. That's something that has come back in almost all inquiries that have addressed a particular failure, a particular episode, in particular the Francis report, for instance, as well. And this is why now the duty of candor is a legal requirement. That's just one example, but it is, so we see that there is an issue of not knowing what is actually good practice, and maybe in the past there wasn't so much clarity between what was good information to patient, what wasn't. There is a difference with incompetence and not actually giving the patient the right information just because we're not actually doing our job properly. And there is a higher degree of deliberate and a deliberate lack of information, because that might be because there is a systemic issue behind it, but it might also be because there is a culture within that particular institution of hiding things from patients. So there are different degrees of I would say bad practices, but I wouldn't call bad practices the first example. So it's difficult to qualify it.
Just following on from that, to what extent do organisations which employ clinicians, so hospital trusts or health boards, or organisations such as professional organisations to which clinicians are a member, to what extent do they have an obligation to ensure that those who work under them or within them adhere to their ethical obligations?
So we've talked about various strands of regulation. On the one hand, there's individual regulation, so and we've mentioned the GMC and the fact that it used to be quite responsive and reactive to problems that had been brought before it, but now exercises revalidation to try and make sure that doctors have the right sort of skills. So there's individual, there's professional, there's also institutional. So there are the Care Quality Commission, for example, will both respond to complaints, but also inspect institutions to make sure that they are following standards. And that includes standards in relation to informed consent.
I think also, as we've got a growing number of doctors who have emerged from medical school with an interest in or commitment to ethics, we've seen the Royal Colleges establish very active, not only active committees, but groups. We have associations around particular areas of medicine that seek to ensure that people understand their shared ethical responsibilities and debate very openly and transparently issues that might be of particular importance within their specialty. And certainly, for example, in the area of genetics and genomics, they're very lively multidisciplinary groups that have been going for many years, where people in their own time and of their own volition come together to discuss and hopefully better understand the ethical challenges of their work. So whilst we've concentrated to some degree on problems and issues, at the same time there is a growing sense of recognition and commitment to this being something you continue to think of through your career, albeit a minority of individuals involved as actively as that, but they do have a voice and can sometimes very directly advise or suggest to their peers in a way that a more distant organisation might not have such an impact.
I think historically institutions or employers have had a clear obligation to ensure that their employees are behaving legally, and there's been recourse to hospital lawyers and advice in that regard. But in terms of ethical oversight of practice, it's been left historically for peers and the profession themselves to monitor rather than employers or institutions. I think that's probably changed now to some degree, that institutions would see that they're not only responsible for their employees to behave legally, but also ethically. But that was left to self-regulation in the past rather than being seen as an institutional responsibility, is my take on it.
The next question is for Professor Savulescu. I don't know whether you'll be able to answer it, but in terms of the Journal of Medical Ethics, do you have a sense of what its prominence was, particularly historically, but also now, in terms of the extent to which it was read or issues raised by it might have become known to clinicians rather than, and not just ethicists and academics?
Well, I would invite Bobby to also comment on this because she's been in the UK longer than me, and I took over from Rhiannon Gillen, I think, in 2001. To be honest with you, I think that ethics is still seen by the profession as a peripheral issue. I don't believe that the Journal of Medical Ethics is hot on many clinicians' desks, and I think its penetration is and always has been minimal within the profession. There is an extraordinary amount of self-belief within the profession that they are ethical experts, and to give you one striking example, which I think illustrates the state of medical ethics in the medical profession. I mentioned the case of Charlie Gard. When I was the editor of the Journal of Medical Ethics, I saw this case when it was first reported, before it became international news, and thought this raises very interesting ethical issues, and proposed to the British Medical Journal that Dominic Wilkinson and I, another professor of medical ethics and editor, write a piece about the article. And their response was, there is nothing new or interesting about this case. And this was their response to two professors of medical ethics and editors of the Journal of Medical Ethics. It went on to be world news that Donald Trump and the Pope became involved in. The Lancet immediately picked up that pair of articles, but that illustrates the degree of self-belief that traditional doctors have in their intrinsic knowledge of ethics.
Professor Phosphides.
Yeah, I agree that can be problematic. I think also there is a growing opportunity for ethicists to publish within the medical literature. So one does get invited from time to time to write for the BMJ, the Lancet, or one might put a paper into an anaesthetics journal, etc. But sometimes the way in which the editors want you to reduce down and simplify what you have to say, and God forbid put it in charts, makes it difficult for you to convey the complexity that we keep going back to time after time. So I think when we really want to think a subject through, we tend to stick to our own journals and hope that we can then, on the basis of that, produce something that might be read more widely in either the medical press or in specialist journals. But that's not without its challenges.
And then, given the references yesterday, I think, to the discussion of Kantian philosophy and the reference in your report, I think, to 18th century cases on informed consent, the answer to this may be clear, but I want to ask it as I've been requested to in any event. Over the period of time with which this inquiry is concerned, so the second half of the 20th century to date, would it be right to say that patients have always had the right to be provided with information such as to be able to give informed consent to treatment, leaving aside, of course, the exceptions that you've already discussed, but in principle, the right and the importance of informed consent has always been recognised with different degrees of emphasis, perhaps, during that period? Professor Cave.
Yes, subject to your proviso at the end with different degrees of emphasis. We're talking about rights, we have to work out what sort of rights we're talking about. So if we're talking about legal rights, it has developed more slowly than perhaps moral and ethical rights.
And then, Professor Cave, when we were looking at the guidance, the the 1970 BMA guidance, you made the observation that this was BMA guidance and not GMC guidance, and therefore didn't attract the sanctions that non-compliance with GMC requirements might in terms of GMC processes. To what extent do you think a lack of sanction has affected adherence to fundamental principles of medical ethics? Sorry, we can't hear you, Professor.
The point I was making was that things have changed over time with regards to the link between the GMC's ethical guidance and the possibility that they might be held to account in terms of fitness to practice. That's been a gradual change. Yeah, that link has become stronger over time. So still, guidance is just guidance. It's not law. And there may be a reasonable excuse for not following guidance. And that would be something that the GMC would be interested in. But perhaps it would explain a closer following and a closer allegiance to professional guidance if there is a possibility that there may be questions as to fitness to practice if they don't follow that. And that's strengthened even further, perhaps, if there's a possibility that they might breach the law in relation to criminal law or medical negligence. Does that answer the question?
Yes, I think so. Next question I've been asked to ask, again, goes back to the issue of paternalism, and it's this. Was paternalism a form of coercion?
Well, I think I think it's, in reality it was, but the generous interpretation, I think, as I said yesterday, is that I think doctors believed that patients were coming for the treatment and prevention of their disease, and that's what they wanted. So what they implied consent to whatever was necessary, that they believed necessary as medical experts to achieve that. So it was a belief that there was implied consent that may not have been the case. So it was paternalism, but it was a certain kind of paternalism where there was a genuine belief that this is what patients want. And I think that has begun to crumble in the last 30 or 40 years. But it wasn't straightforward, we're just going to do what we believe is best for you. I think there was a belief that, and in many cases it was true, that this is what patients also wanted. Would others disagree with that?
No, I wouldn't disagree, but I wouldn't go as far as to say that it was coercion in law, at least, no. Because there was a legal distinction between valid consent and informed consent, and there still is that legal distinction. So for consent to be valid, it must be voluntary, it must be capacitous, and it must be minimally informed. So not giving that additional information wouldn't be seen as invalidating consent. It would be seen as not giving sufficient information, which would then invoke the possibility of a negligence claim. So it's a complex sort of legal issue, and you could argue there's a moral case for a degree of coercion, but in law that wouldn't be the case, I don't think.
I think it's also important to realise that society it's hard to imagine people now going to fight in the First World War. I think people's expectations and social norms and coordination has changed over the decades, and I think the 1980s was a period of quite significant change in terms of people's aspirations and expectations for their own life, their deference to authority, and that continues today. So one of the benefits of the guidelines that the GMC and the BMA put out is they set out a set of expectations at a period of time, but those are always changing, and as I said, I think that the doctor-patient relationship in the 1940s would have had quite different expectations and experiences from the doctor-patient relationship today.
I think the particularly unfortunate characteristic of the examples we're thinking about and discussing is there were very few other places to go to get the information that was being withheld. So one's voluntariness was very substantially undermined because the person that you trusted to tell you what was important, what you needed to know, had decided for themselves that you didn't need to know, or that your knowing would be too damaging, and therefore balancing considerations, they chose not to tell you, or for all the examples we discussed earlier. And nowadays we have so many places to turn for information, for opinions, sometimes dangerously so, because we can't trust all of it, and we still need our clinicians to help us filter out the erroneous information, to understand the relevance of sometimes mountains of information that you can access. But at least there were those other possibilities. If one is reliant upon an individual or a particular team to essentially inform you of the important aspects of your care, and for whatever reason that doesn't happen, it does feel as if you've been disadvantaged.
The next question relates to the therapeutic privilege. Would imposing a treatment on a capacitous patient in the absence of informed consent, because the clinician thinks it has medium to long-term benefits in terms of morbidity or mortality, ever have been ethically justified on the basis of the therapeutic privilege?
So the therapeutic privilege applies today, at least, when it's felt that disclosing a particular risk will cause serious harm. And it's not clear from what you've just stated where that serious harm would be, in which case the therapeutic exception, as it applies now, wouldn't be relevant. I have discussed the fact that it was broader, that in the past, that it was more akin to the idea that doctors should tell a patient what was reasonable, but it still wouldn't necessarily follow that it was reasonable to exclude information about risks and benefits in the situation that you set out.
The harm, I think, underpinning the question, or the notional harm, would be if the patient was given the full information, they might elect to go for a form of treatment which is which the clinician thought would be less advantageous in the medium to long term in terms of morbidity or mortality.
Right, I think it's clear that it wouldn't be ethical on that basis, because it's effectively trying to push them into a decision that isn't a free decision.
And it's important to stress again that people have the right to choose an inferior course of action or no action. That's entirely their prerogative. And I think that's something that doctors have had great difficulty accepting, that somebody would choose a course of action that doesn't maximally promote their health in their view. But that has been established since 1910, the kind of Schloendorf case, or longer. So I think that, even if they choose to have no treatment whatsoever, that's their right.
Do the ethical... Sorry, go on. Do the ethical requirements for informed consent differ at all in the case of chronic patients where the clinician has been responsible for the care of the patients and will continue to be over many years, and there is no alternative to the care being provided by that individual doctor?
There are advantages to the model of care offered to people with chronic illness, in that there might be a continuity over the years that is very reassuring. It means that information is held, history is shared. However, that cannot become a form of complacency. We said early on yesterday about remaining alert to when patients are giving messages that they wish to change their mind on something, perhaps, or their priorities have shifted, or the things that are preoccupying them have changed. And I think the great privilege of caring for someone over a long amount of time as an individual or a team is that you can get to know them and understand them, but that doesn't allow you to make presumptions about what they would or would not consent to in the future. You still have to check, particularly in very important and new interventions, that their consent is valid.
And then the next question is for Professor Varsides. In relation to children, and it may, I think, have been in the context of the evidence that you were giving about research in children, you used the phrase assent. Is there any difference between assent and consent? And if so, what is it, and why does it apply to children?
Sometimes the term assent is used to suggest something a little bit more than agreement or acquiescence, but something that doesn't have the legal force of consent in the context within which we might use the term. So an ambition sometimes with particularly very young children is that you should reach a point where you feel that they understand sufficiently what's going on in order to agree and not resist what is being done to them, and maybe on occasion go a little bit further than that and express an opinion that if they had age on their side, or if they were fully capacitous, would be seen as consent. So it's a sense of respecting that children, particularly children living with lifelong conditions, become invested in and knowledgeable about and able to participate in their care and research before they might have the legal right to consent. And I'd love to see if Emma is happy with that explanation, because she's very much an expert in this area.
Brilliant, Bobby.
The next question picks up on the evidence this morning and the discussion this morning about the failure to obtain patient consent for specific blood testing for infectious disease. There was a discussion about this being recognised around the time of the HIV epidemic. Although it may have been that was the time when this issue came into particular prominence and was the subject of discussion by the BMA and guidance from the GMC, was it not always contrary to patient autonomy to test a patient for a specific infectious disease without their knowledge and consent? And I'm talking here ethically rather than legally.
There is a very famous case from the United States, which I slightly hesitate to mention because I think it's very triggering for members of the Black American community to even be reminded of this. But in this case, which came to be known as the Tuskegee case, a cohort of Black men were tested for syphilis, and then a proportion of those men were left untreated with the express intention of charting the natural progression of the disease. And this is something that we can barely countenance now. But it really made us think that this is a hard case in the same way as the Nazi experimentation is a hard case. But at the core of it is that lack of knowledge, that lack of understanding of what was being done to those people and the lack of ability they had to walk away or object, or even for a very long time get any form of just recompense for what had happened. So I think we are acutely aware of how we wrong people when we do things to them without their knowledge that had and could have profound consequences.
Is there any other observations?
Well, I think I mentioned this morning that it was routine to do syphilis serology on patients presenting with neurological conditions to exclude that differential diagnosis, and people were not explicitly consented to do syphilis serology. And as I have explained, I think the basis for that was that consent was implied to identify the cause of the illness. So while the question is correct that technically it is a violation of the person's autonomy not to explicitly consent them to that. That was a widespread practice, and again, a failure to appreciate the significance of such testing and the importance of people's autonomy.
Is there any relevant difference, picking up on what you've just said, between testing for a range of conditions that you've no reason to believe the patient suffers from, but because you are excluding a range of conditions in order to arrive at a particular separate diagnosis or understanding of the patient's condition, and the situation where you are specifically testing someone because you have reason to suspect that they may have that condition?
Yes, that is a very good point, that if you have a reason to believe, you should be discussing that reason with the patient. That is a relevant difference. Yes, you're correct.
And where the testing is being undertaken to investigate the possible adverse effects and consequences of the treatment given by the clinician, is there then, as it were, an enhanced obligation to ensure the patient's aware that that testing is being undertaken?
Yes.
And then, picking up again on the right not to know, Professor Savulescu, how does a clinician ethically satisfy themselves that a patient really does not want to know the result of a test or a diagnosis?
I have no idea, apart from discussing the possibility with them. So I think this is why the right not to know is fraught with danger. And I think some broad discussion of the issue is necessary to at least get a direction about what the patient's preferences are. We can't assume a right not to know or guess it.
I think you yourself mentioned the issue of Huntington's disease and the relatively low take-up amongst families affected by Huntington's of diseases, particularly in sort of early adulthood. And I think that is a very, having worked with the Huntington's Disease Association a couple of times over the years, I'm very struck by the thoughtfulness that goes into the decision of by a particular individual whether or not to be tested, and therefore whether or not to acquire the information. And but I think that again speaks to the value of being part of a community in which these issues are recognised, and the importance of giving thought to undertaking a test is understood. That's not always going to be the case. One could turn up de novo in a medical situation and a test be taken that had significant consequences for you, and you would only then in the room have the opinion of the person you were speaking to. Only subsequently would you have the ability to engage perhaps with a broader community or look on the internet. And therefore it goes back to something we talked about again, about having sufficient time to make a decision. And part of that decision is, do I want to proceed at all? with this test, given what I now understand about the implications of getting a result.
So I think I've got about another 20 minutes, half an hour of questions, possibly questions and answers. I raise it so that you can decide whether you would like to take a break or whether I press on.
Well, that's a question I think essentially for me, but I am going to do what you did, and ask our panel. We will only go on with your informed consent. Part of the information you need to know is there is always a risk when counsel proposes a time. The time will actually be longer. It is very rarely shorter. But I think if we were to take, let's just say 20 minutes now, the chances are we might be finished by 5:15. Is that fair, do you think, Miss Richards?
Fair, but of course may make no allowance for questions you have, sir.
No, at the moment I have one. So, but there we are. So the question is, do you want to go on, or do you feel in need of a break, or not? But if anyone wants a break, we'll take a break.
I'm completely open to either option.
Me too.
I'm happy to go with the flow.
Dr. Kazarian?
Me too, sorry. Yes, I'm fine with that.
Are you content to go on, Miss Richards?
Certainly, yes.
Well, so am I.
The next question is one I don't know the extent to which you'd be able to assist, but I want to ask it anyway. And it concerns the position of doctors who would be involved in the collection of blood within blood services, but not then involved directly with patients who are the end users of the blood or the products derived from blood. Do you have a sense ethically of to whom doctors in that position owe ethical obligations?
Again, I think we're all missing Ian with this question, but I wouldn't have perceived blood being collected in quite that way, although, of course, interestingly, the blood with antibodies for people who've suffered COVID is a very recent example that I don't know the details of, but might be collected in the hospital. I don't know. What I am aware of is the very strong ethical responsibilities now felt by the blood transfusion service as an organisation, that it has national responsibility for collecting blood for medical use and producing blood plasma, etc. And I would say that my observations of their approach in both working alongside them both in the VCJD incidents panel and in relation to the organ donation task force is that there are very clear standards of ethics in relation to their donors, and sadly informed by the events and issues that we're here to reflect on and think about and discuss, to recipients.
So I might just add, my understanding is that anyone putting a needle into a patient needs to ensure that informed or valid consent has been given. So a more common situation is where a patient comes to surgery and the anaesthetist must put in a line prior to surgery. Now, the anaesthetist needs to ensure that the patient has given properly informed consent, but they don't need to obtain fully informed consent themselves necessarily. So I would have thought in the situation you described that the person taking the blood needs to be sure that in some way the person has given valid consent or obtained that themselves.
And forgive me, my question was insufficiently clear, and that's my fault. I was talking about those clinicians who work within transfusion centres or the transfusion service. To what extent do they have ethical obligations to the end users of the blood that's being collected and maybe used for transfusion or used for the manufacture of blood products.
Oh, that's passed on to another party. Oh,
sorry. So that.
Sorry, now I understand the question.
I don't know whether you can assist or whether it's too specific a context.
There are clear obligations to screen as far as is possible the blood and ensure that it is a safe product. Unfortunately, we know that that has not always been possible, and certainly those discussions became very live again around the issue of VCJD. And one of the steps that is sometimes taken is to limit the eligibility of people to donate, which is something that limits their autonomy and takes away from them the possibility of doing something that they probably value greatly. But they understand that if there's any risk of their blood contaminating the blood supply, that is a choice that might have to be taken. So I think I can only speak from my experience of working with professionals in that area that they are to some degree haunted by the possibility of a contaminated blood supply, and many ethical issues follow on from that, including very difficult discussions around what to do if the first time someone's blood has been tested is because they presented themselves as a donor and had maybe no reason to believe that they were carrying a transmissible disease. And some had suggested, well, all you need to do in that occasion is dispense of the blood, and you no longer have a dangerous situation for the end user, as you put it. But actually, what about the responsibility to the donor to inform them of something that is very relevant to their health? So that's the level to which I have personally observed discussions taking place within the blood service.
Dr. Kazarian?
Point. So I would say that yes, it is important for the end users to know what's in the actual product, and that would also be a legal requirement to inform them of the potential risks there might be if they use that particular product, and that also applies to blood products.
The next question is about ethical guidelines. We've looked at various guidance. We've looked at the Declaration of Helsinki, BMA and GMC guidance. To what extent do you think there should be, in a national healthcare system, such as the NHS, a single national ethics code or a body with national standing able to issue ethical guidance that isn't a regulatory body or doctors' union? Professor Cave?
Well, this is a very complex issue, and I'll turn to Bobby immediately afterwards because she may be able to say more about this than I will. We don't have a national ethics committee, but we have something that comes very close, which is the Nuffield Council of Bioethics, which does really marvellous work in relation to discussing these issues and making sure there's public engagement about issues, etc. But we don't and haven't had a national bioethics committee, and some countries do, and they can be very useful, but won't necessarily produce something that's definitive and which has absolute consensus, as we've seen recently in the COVID crisis. And so what has tended to happen is that as Royal Colleges have developed specialties, they can speak to those particular specialties in a way that resonates with that particular profession and responds to particular issues that profession might, that particular aspect of that profession might face. And this is a good thing in many ways, but it's also problematic if you end up with lots and lots of different guidelines that perhaps conflict slightly. And again, we've seen that in the recent COVID-19 crisis, lots and lots and lots of guidance, some of which may conflict. So I can see why it would be advantageous to have a single ethical code, but also I think highly unlikely that it would be specific enough and relevant enough to the different specialties.
Professor Phosphides?
Yes, I think we could probably go on far too long about this. It's a very live issue at the moment. And personally, I'm not rushing to get a national ethics body. And I, too, have huge respect for the Nuffield Council on Bioethics. And if you speak to the people that work there, they say one of their great strengths is their independence and their ability to challenge and to offer reports that are sophisticated, nuanced, complex, and don't necessarily give politicians and policymakers an absolutely straight line to follow. And I think that anybody that's listened for the last 2 days will see that that's where we feel the value of ethics lies, in revealing and exploring complexity and difficulty and offering alternative perspectives. And my worry is that a national ethics committee could become too close to politics. It could be beholden to, I think one of Trump's early acts was to disband the national ethics body in the States, the President's Commission. And we don't want high quality advice to be in any way dependent upon political support or patronage. So it's not to say that some national bodies haven't done very good work on particular issues, but I think a degree of independence is to be valued.
The next questions, in a sense, emerge out of what one learns from reports such as those referred to by Professor Cave and in particular the Cumberland Review. And it's really about what systems there are to capture patient experiences post the licensing of a product. Are there, or is there anything that ethics can tell us about the gathering of information about subjective matters such as pain, or information from patients about their experience of new products? Professor Phosphides?
I'm sorry, I lost you slightly for a moment, so please forgive me if I don't fully address your concerns. But I took you to be asking whether there's any way of capturing more subjective accounts of medical experience, particularly around issues such as pain.
That's part of it, or capturing patients' experiences of new products, side effects that they may be experiencing. How can that information post-licensing be gathered and captured and then shared with future patients?
That's a very good question. Well, I think funding bodies such as the Wellcome Trust, the European Commission, the MRC have become increasingly interested in understanding what the experience is of patients, either in innovative fields of medicine, in very established fields of medicine where there are still unresolved issues, or those who have been part of complex clinical trials or longitudinal studies. And what tends to happen is that you then get social scientists, ethicists working to look at the experience of patients in those fields. So, for example, the medical sociologist Anne Kerr has just published an excellent study of the experience of cancer patients who have been offered the possibility of personalised treatment through the increased knowledge around genetics and genomics as it relates to cancer. So her interest all along has been, what were the expectations of these patients? Were they met? What did she observe in the consultations between them and their consultants and other healthcare professionals to suggest whether they understood fully or were being told fully what the tests or results that were being dealt with actually meant to them. So I think there's more of a multidisciplinary interest in these questions of the experience of people who are undergoing testing, treatment. I myself have done work in relation to antenatal screening and testing. Many, very good scholars have made their careers by focusing on making more public the experience of patients and sharing that knowledge, not just with other patients, but finding ways to feed that knowledge back to clinicians so that they can understand better. One of the most wonderful PhDs I've supervised in recent years was where Dr. Jane Peake spoke to 37 people who had suffered from Parkinson's disease over a period of between 3 months post-diagnosis to 30 years. And some of the things that she uncovered in that were invaluable in challenging dominant medical perceptions of what a diagnosis of that type can mean.
Professor Cave.
It's clear from the Cumberland report that the system that we have at present is inadequate, that it doesn't do enough. There are various methods of post-market surveillance, and in a way, we're all research participants when it comes to novel drugs. Novel drugs that have been licensed, they've gone through a process, they've gone through clinical trials, they're recognised as safe, but then there is a period of time, and that period of time may go on for a very long time, whilst there is post-market surveillance. We know that innovation is dangerous without proper post-market surveillance, and we know also that doctors and patients can't understand the risks properly if they're not given the full information, and therefore they can't make informed decisions. One of the systems we have at the moment is a yellow card scheme where doctors and patients are able to upload onto a website experiences of any adverse reactions they've had. But we don't really know how accurate those reports are, and we don't know how often they're made. I mean, there may be many instances where there are adverse reactions where nobody makes such a report. So there are real gaps in the system. And one of the things that is proposed from the Cumberland report is that there should be a new patient safety commissioner, and that is being taken forward in a bill at present.
So this is not really my area, but one thing I'm aware of patients or patient groups organising themselves. So, for example, motor neurone disease patients connecting through the internet and social media, sharing experiences or sharing information. So another way I think in the future would be to connect patients to enable them to share experiences and drive the research agenda from the ground up, or democratisation of this kind of surveillance. Another issue is that, with big data, we have enormous capacities for greater evaluation of these sorts of events. But that will require dealing with privacy and confidentiality concerns and rethinking the way in which we gather data about drugs and devices and other interventions.
I think Julian makes a really important point, and it's particularly relevant to families with rare disease who may have thought that until now they were the only people in the world, literally, to be dealing with the situation. Instead of which, through the power of the internet, the creation of the rare disease community has grown, and the alliance between pockets of that community and particular scientists, not even clinicians, basic scientists, is one of the most exciting things to emerge, so that people don't feel that they're therapeutic orphans in the way that you can again be with a rare disease, because suddenly there are people, albeit on the other side of the world, where data can be pulled, scientific interest can be encouraged, and work with clinicians interested in the field can proceed because they have a pool of potential participants when they are able to offer research. And if you attend a rare disease conference these days, that I think that's one of the most exciting things that is presented to you, this sense of an alliance growing that is global and allows science, medicine and patient experience to come together.
And do any of the panel have views on the merits of the Cumberland recommendation for a patient safety commissioner? Professor Cave?
Yes, I think it's absolutely marvellous and necessary.
Does anyone have a different view? The penultimate area of questioning, it really again picks up upon what Professor Cave has referred to in terms of Cumberland and mid-staffs and the Ockenden report and others. It would appear from those reports that there remains in 2021 a problem of doctors still not placing patients first. What do the panel think are the cultural or institutional blocks to this happening? And from your perspective, how can fundamental change be effected to address that problem?
So maybe I'll start, because I do have a kind of position on this. So it was expressed before by Emma that the Shropshire problems was a failure to respect women's autonomy, and that's certainly correct. It's been a legitimate option for women for over 20 years to elect caesarean section, but it's been an option that has been rejected by many medical professionals on their beliefs about the interests of the woman or the fetus. And so I think one issue is really education around the importance of autonomy, but also about rethinking how we conceive of risks and benefits and what really is best for people. Because this has the Montgomery, the Ockenden, all of these reports refer to women being denied a very reasonable option. And this idea that there can be multiple options of care that have different risks and benefits that are within a tolerable range, and that people's autonomy is important to respect, are both elements, I think, of medical ethics education that need to be. We need to produce a better group of clinicians who can think more broadly about what is benefit and also take account of people's autonomy more. So I think having more commissioners and more regulation may help, but I think the problem is deeper than that. And it's about people enforcing their own ideology or their own faith in what they believe is best for people, which is not either properly evidence-based or not properly ethically based on a broader conception of well-being and autonomy.
You talked in your question about the problem of doctors not placing patients first, and I think it's true that there are examples of that. But I think we also need to be clear that it's some doctors. In fact, it's some healthcare professionals. And there's also problems with the system as a whole that leads to some of these issues. I think Julian's quite right that education is key here. There are other problems as well, and we could talk about them for hours and hours. Just to name a couple of them, I've already mentioned yesterday the clinical negligence system that we have, which is fault-based, which gives an incentive to keep quiet about certain things, which is problematic. I've also mentioned failure to protect whistleblowers in some instances, which is hugely problematic. But I think perhaps one of the biggest issues is that of funding. the lack of time, the lack of resources is hugely problematic in the NHS. And it's trite to say that this is what it comes down to sometimes, but I think we do need to at least acknowledge that factor.
I think I have wanted to bring this up. I don't know exactly the figure, but the UK spends about 8.5% GDP on healthcare. Most other advanced European countries spend 11 or 12%. And at the end of the day, it's just been a healthcare system run on a shoestring, and you get what you pay for, really. And these are really deep problems that I feel somewhat affronted when I'm told to stay home and save the NHS. I mean, the NHS should have been saved over decades through proper investment. And yes, all we can do now is stay home, but there is radical underinvestment in the NHS, and that is certainly a significant part of the problem. It's not the only contributor to the problem, but I think this is a time where I hope that you will take a courageous step and encourage politicians to invest properly in their healthcare system.
Professor Fawcett? Sorry, Dr. Kazarian.
It is a complex question, and it is a question that we could talk about for a long time. But I think what Emma has pointed out is important. It's only some doctors who do not put their patients' best interest first. But I think from what we see from the different inquiries that have come out on different episodes, there was a problem, and there is still a problem of ineffective regulation of medical practice, and also of the lack of transparency, and the issue of whistleblowers, as Emma has pointed out, the fact that whistleblowers were not given voice, were not respected, and things were not being fully explained to patients. So that's been a problem in the NHS, and is still a problem to an extent. And I think regulation will be very important in order to address that as well.
Professor Fawcett.
Well, I would want to endorse what's been said. I agree with Emma that we mustn't lose sight of the many healthcare professionals, particularly at the moment, who are very much putting patients first, often at personal risk that has been exacerbated by a lack of appropriate support financially and organisationally. And I think we have to think seriously about what it takes to offer an ethically robust health system. Back in the 1950s, the political philosopher Plamenats put forward an account of what it meant in terms of consent if you voted in an election. And he said at the end of it, if you think that what I'm saying is the definition of consent that I've given is impractical because that's just not the way things work, it's not necessarily the case that I have to change my definition. It might be that we have to change the system. And I think sometimes when you see things go wrong, it's because people simply can't meet the standards that we as ethicists would like them to meet because of the way in which a system has been denuded of finances, or where attention hasn't been paid to organisational problems, systemic issues. And whilst I think we're doing our best in terms of medical education to try and support individual doctors in being the best they can, and also by things like widening participation, correcting the profound gender imbalance that existed at the time some of the documents we've looked at existed, we're trying our best to train good doctors, but with all the will in the world, if they then emerge into a system that makes demands upon them that is completely unreasonable, then the patient remains at risk.
My final
Well, I think
question.
I'd like to echo what Bobby said. I mean, I think there are some of the best doctors and health professionals in the world in the UK. And I've certainly benefited from their care. So I think that's the starting point. But they're operating in a system that isn't fit for purpose. The UK has one of the worst cancer survival rates in Europe. And that's not because of the quality of the doctors. That's because the system needs to be revised. And I think you're just seeing inquiry after inquiry, and I think it's time to move into the 21st century.
My final question was going to be to afford Professor Savulescu the opportunity to raise the issue of NHS funding, but I think through the last question you've been able to do that, I hope. So, sir, over to you.
Yes. Just one issue, if I may. It goes back to what was said by you, Professor Savulescu, earlier, when you were speaking about the question of research, and if it was published, if any document was published, it was likely to be research. And it led me to wonder whether one of the controls on whether there should be proper ethical approval, a paper which might be published, is that a journal might require there to be evidence of such approval before publishing. It may be a common practice. Is it common practice that journals seek a proper assurance that there has been ethical approval for that which they are to publish?
Yes, it is now.
There be.
It is now. Now journals, as far as I know, all, but certainly typically in the major journals, all require evidence of ethics committee approval. And as I mentioned, typically when patient data or information is published that the patient has consented, but you'll always see now on a journal article nowadays that this has received ethics committee approval. So journals have tried to, and editors have tried to exercise some quality control in that way.
That would itself create the expectation that anything which might be published should have ethical approval. That's the first thing I tell my students is that, if we want to publish this, we have to get ethics committee approval. So that's a relatively recent phenomenon. That certainly, wasn't the case last century that journals required ethics committee approval before they published the paper. So when roughly did it change in this millennium? I'm thinking around the turn of the millennium, journals started to require that. So that's my guess. I don't know if the others have a more accurate memory of that, but I think in the 80s and 90s that wouldn't have been standard practice at all.
I still think there's a sort of intermediate position, and it's certainly something that I have provided to people as a chair of an ethics committee, which is where something is very clearly audit or health services evaluation, but there is an intention to publish, we will ask them to fill in the same form as if it were a research protocol. We'll look at it, but the letter that we provide will state very clearly that it has been presented to us as audit or health services evaluation, because I think there is a merit to keeping that distinction clear if you're being straightforward and accurate in the way that you use it.
Is there anything?
That's all that I have to ask.
And is there anything further which any member of the panel would wish to add that we haven't covered?
Could I just say something which I would have liked to have said at the beginning, but my internet system let me down? We've spent 2 days discussing complex principles and theories and documents, but I think we're all very minded of the fact that these are of great interest to people listening today whose lives have been touched in a very profound and real way by the issues to which we are applying these somewhat abstract ways of thinking. And I would just like to say that personally, and I know that people will speak for themselves, but I know we share this, that we've been very moved by the testimony that we've heard from core participants. And whilst we haven't touched upon their direct experience and their stories, they haven't been far from our minds when we've been speaking with you over the last 2 days.
I'd just like to echo that. It's been a huge privilege to be of some assistance to the inquiry, and it was an honour to attend some of the hearings. I was lucky enough to go to Leeds and to Edinburgh, and to hear firsthand the accounts of the infected and affected, and also to meet some of them in the breaks and at lunchtime. So thank you very much for that.
Well, I mean, maybe I should declare a sort of slight conflict of interest at the very end here, because I think I graduated from medicine in 1988, and I looked after patients with haemophilia. I was in a hospital which was a major haemophilia treatment centre and also a major HIV treatment centre, and I looked after patients who died of AIDS and who had HIV from blood products. And, you know, I know firsthand that at that time, I think in our hospital, patients got the best possible care, but many people, many clinicians, including myself, often were embarrassed or ashamed, and we viewed patients with haemophilia as a failure of medicine. We had promised miracles and given them HIV, and for that, you know, as a part of the medical profession, I would like to apologise. I can't say anything about the decisions of Sir Brian, but I do hope that you get the justice and compensation that you deserve, and I hope that we can move forward into the future and identify the ethical failings and do better in the future. So I look forward to Sir Brian's report, and I hope to write about this in the future.
I'd like to echo that as well. I think it's been a long time coming, and I feel very grateful for being part of this panel, because finally we were hoping that the victims, their family, and many patients will have the justice that they need.
You've spoken about the privilege of seeing some of the hearings, you Professor Arsides and you Professor Cave. You've spoken about your experiences, Professor Savlescu, when you were a young doctor. And you said that it's been a privilege to give evidence for the inquiry and to be involved in it. Actually, it's our privilege to have had you. You have, over the last 2 days, given us a really valuable understanding of how ethics may fit in. Those who have been watching, who perhaps wondered why there have been less direct questions about particular instances of a failure, as they would see it, of the treatment they may have had, whether as people with haemophilia or people who simply had a transfusion of some other condition, why they haven't had the ethics of that particular situation explored and explained. But that will be to focus upon the individual, and we've been focusing upon the general, the lie of the land. And what you have done is you've given the inquiry and those who participate in it the tools, the ethical tools, to help to understand and dissect some of the evidence we've had, to understand where there may have been ethical failings, inappropriate action, shortcomings, as we now see them. And of course, we are judging necessarily from a perspective of 2020, 2021, maybe 2022, what may have happened in the past. You've shown us, I think, really how complex, how sophisticated, how nuanced, those are the words that you, Professor Parsides, used, ethics can be, but the value of it in considering, exploring the issues and looking for other possibilities, and a much clearer appreciation, I think, of how those nuances, those complexities actually play out in practice. And I really do want to thank you, as I thanked Professor Kerridge earlier, for your time, your effort, and what, for my mind, is a very good, well-written, very helpful report. I look for meeting you further when circumstances permit, but thank you all, one and all. I do have something to say now to those who are watching online. By all means, sign off if you'd rather. Otherwise, you may have to be detained for another 5 minutes. That's, I hope, not going to be 10. But it is this. If I can address the wider audience who are watching, the eagle-eyed amongst you will not have missed that Dr. Jones, Dr. Peter Jones, was earlier timetabled to give oral evidence next week, but there are now no plans to call him to testify. Well, I promised that this inquiry will be as transparent as the law permitted, and to make good on that principle, you're entitled to know why Dr. Jones will not be giving evidence orally. It's because, after considering both submissions on his behalf under Section 21(4) of the Inquiries Act 2005, supported by evidence, as well as the public interest in hearing orally what he may have to say, I have determined that it would not be reasonable in all the circumstances to require him to do so. This is a good point at which to explain why certain potential witnesses are not giving oral evidence. A consequence of the time it took before a statutory UK-wide inquiry was decided on is that many of the matters we are investigating date back many years. Some potential witnesses have developed health conditions that mean that they cannot now give evidence as once they would have done. Some witnesses have been able, with difficulty in some cases, to give a written statement, but not to give it orally. Some are able to give neither. In each case, I start from the basis that if it is desirable to have evidence from a witness, the inquiry should get it. I have powers to compel it, which I am quite prepared to use. It is necessary to have compelling material to persuade me either that they cannot do so, or that it would be unreasonable, taking everything into account, that they should. The inquiry statement of approach, entitled Information for Witnesses, is published on the website. It sets out the process so that anyone can read it. Paragraphs 18 to 20, in particular, are applicable. Each case requires separate, often painstaking examination. Each is different because the particular situation of each witness is different. I have to make a judgment, too, about the public interest in hearing from that particular clinician. It is only after consideration, careful consideration, their individual circumstances, that I've come to the conclusion that some of the clinicians who were directors of haemophilia centres and attended UK HCDO meetings in the 1980s are not in a position to give evidence. What this means is that the inquiry will not be taking oral evidence from the following haemophilia clinicians who it would otherwise have wished to call. Peter Jones of the Newcastle Haemophilia Centre, Charles Ritzer of the Oxford Haemophilia Centre, Richard Wensley from Manchester, Frank Hill from the Children's and Queen Elizabeth Hospitals in Birmingham, Elizabeth Main from the Royal Victoria Hospital in Belfast, Morag Chisholm from the Southampton Centre, and Leonka Swinburne from the Leeds Centre. Some have been unable to give written statements. And I hope that helps those of you who may have been wondering about when we might hear from those witnesses. Turning back then to next week. Ms. Richards, we resume on Tuesday, do we not? Starting at 10 o'clock with a presentation on the first Cardiff AIDS patient, Kevin Slater. That's something which you promised, I think, during the evidence at the time we were listening to Professor Ludlam. Be followed by a rather longer one on the Newcastle Haemophilia Centre.
So
do we have anything next week, Ms. Richards?
No, that's all. And I should say, in relation to the presentation on the first Cardiff AIDS patient, we have previously not named him for obvious reasons. We now do so with the knowledge and consent and agreement of his family, to whom we're very grateful for the assistance they provided in furnishing us with information about him. So we will be looking at his case in terms of what it tells us about the knowledge of risk and in the course in particular of 1983, and there is a presentation that has been or shortly will be provided to core participants, and then we will for most of the rest of the Tuesday and Wednesday be looking at Newcastle.
So Tuesday and Wednesday next week, starting at 10 o'clock on Tuesday.
Yes.
Thank you very much. Thank you all.
Thank you.
And good night.